distinguished guests, respected speakers, faculty members, scholars, and participants present here, as well as those joining us online. On behalf of National Law University Tripura, it is my privilege to welcome you to the Day 2 morning session of the 3-day international conference on integrating legal frameworks and management strategies, pathways to a greener, sustainable Northeast India. Yesterday, we witnessed insightful deliberations that set the tone for interdisciplinary engagement. Today, we continue this journey by engaging with eminent voices who bring together law, governance, and environmental thought. Now I request our respected Vice Chancellor, Professor Dr. Yogesh Pratap Singh, to kindly welcome our keynote speaker of the day, Dr. Sumanta Chakraborty, Registrar, MBB University. Thank you, sir. May I now respectfully invite Dr. Bandita Sengupta, co-convener of the conference and assistant professor at National Law University Tripura, to kindly deliver the welcome address.
Thank you, Pragati. Good morning to all, distinguished dignitaries, respected patrons, esteemed advisors, honor speakers, delegates, participants. It gives me immense pleasure on behalf of NLU Tripura and as a convener of ILFMS that I welcome you all to the second day of 3-day international conference on integrating legal frameworks and management strategies, pathways to greener, sustainable Northeast India. I hope that the deliberations and discussions on the first day were intellectually enriching and have set a strong foundation for the sessions ahead. Today, we move forward with renewed enthusiasm as we begin the morning with our plenary sessions, which promises to offer deeper insights into the intersection of the legal frameworks and management strategies in advancing sustainability in the Northeast region. We have privileged to have with us eminent experts and thought leaders who will be sharing their valuable perspectives and experiences. Their contribution will undoubtedly enhance our understanding and inspire meaningful dialogue towards sustainable development. I would also like to take this opportunity to express our sincere gratitude to our respected patrons and advisors for their constant guidance and support in making this conference a success. As we commence today's proceedings, I encourage all participants actively engage, enhance and exchange ideas and contribute to the discussions that aim to shape a greener and more sustainable future. Once again, I extend a warm welcome to each of you and wish you a productive and insightful day ahead. Thank you. Jai Hind.
The Northeast region, as highlighted in the conference concept note, represents not only ecological richness but also complex governance challenges requiring a harmonization of legal frameworks, policy innovation, and sustainable management strategies. Today's keynote speakers embody this very integration, bringing perspectives from administration, international law, and global environmental governance. It is my honor to introduce our first keynote speaker for the morning, Professor Dr. Manoj Kumar Sinha, who will be joining us online. Moving ahead, it is my privilege to introduce our speaker, Dr. Manoj Kumar Sinha is currently working as the Vice Chancellor of the Dharmashastra National Law University, DNLU, Jabalpur. Prior to joining the DNLU, he served the Indian Law Institute as its director. He did his doctorate in international law from Jawaharlal Nehru University, LLM, from Jawaharlal Nehru University, LLM
So
from the
I think,
university.
you can stop here and then, so let me continue. Thank you very much for introducing, and it's a great pleasure also to see Honorable Vice Chancellor Professor Yogesh Singh, all and other eminent persons on the dais, of the dais. And also I would like to extend my sincere thanks to Honorable Vice Chancellor and you for accommodating my request, because I was supposed to speak at 10:40 to 10:55. So thank you very much, Professor Yogesh, accommodating my request and allowing me to speak as a first. And I also thank all the honorable respected dignitaries on the dais. This broad theme is very important. Like, when I saw there's a 3-day international conference on international legal frameworks and management studies, pathways to a greener, sustainable Northeast India. There are two important aspects in broad theme. How, the global framework related with the environment has to be integrated in handling and ensuring the sustainable development, sustainable environment, and specifically with reference to the Northeast India. I had an opportunity to visit on many occasions in Northeast India, so I'm very much familiar the need. And already, there's a culture in Northeast that most important, a culture prevails in the Northeastern society, which is missing in other parts of the country. Destruction of forest is very in rampant and common in other parts of the country. But when it comes to the Northeastern, it's a way of living. People have been from generation to generation. It's a customary. They respect the forest. Their forest is integral part of our environment is integral. Forest, river, everything is integral part of the society, and that is also very important for the growth of the society. And so the entire northeastern states has a very deep root in protection of environment, importance of environment in its preservation, its protection. So the efforts automatically comes down when it comes to the northeastern states, and even in the tribal society in the Jharkhand and in some parts of the country, we see there, even the Madhya Pradesh, the tribals, they worship the forest. They are very much attached with the forest. When we talk about the international global framework, we see its imprint in our domestic law also. We start our journey from the 1972 Stockholm Declaration. That is the first global initiative to enter in a domain which primarily everybody thought it's an state jurisdiction, a sovereign state, which will take care of that. But by 1972, there is a need for close collaboration among the nation states for the protection of the environment. And the initiative was taken by the Sweden. The Olof Palme was there to initiate. And it is important also to note that the only two prime ministers participated in the Stockholm Declaration conference, which took place in the month June. And the first, Olof Palme being the host, he was there, and Indira Gandhi also participated in India. And since then, our local laws have been started developing. If you look into the very objects and purpose of each law, it says that we participate, India has an obligation, whether it's a Water Act, Air Act, whether it's a Environment Protection Act. Every act in the beginning, it recognizes we have a global obligations. And our good friend is a constitutional law expert, Yogesh. So states have, because environment is the state subject, and when it comes to the legislation, the member states, the federal states in India, all states have requested the government of India or union government to adopt legislation under Article 252 of the Constitution. It is like, so they said, so 6, 7 states they requested we need, so Article 252 has been ground for the all the legislation for there, because it's belonging to the state subjects, but state has said, we have to work together, and all the legislations have come into there. There is an effort also some way, unfortunately, in a diluting of the whatever the regions is there. Jan Biswas bill, it has decriminalized certain environment provisions. Jan Biswas bill has affected many legislation, including Environment Protection Act is there. We keep it aside. These are the more important. And another important point which I just noted in brief in the studies in the newspaper, and many of you might have seen also, after the adoption of United Nations Framework Convention on Climate Change in 1992, since then, every year, Conference of Parties meeting takes place in the world. Like recently it happened in the Brazil, last meeting in the month of November. And every year Conference of Parties meeting takes place. Year 2028, so maybe officers will be, Ministry of Environment and Climate Change officials will be a more appropriate person to discuss about. 2028 was the year that was slated for the Government of India to conduct the Conference of Parties meeting, annual meeting of Conference of Parties. But it had got cancelled. So what are the reasons, we don't know. But Government of India, generally the current government is very keen to take initiative when it comes to the global summit, like G20, other summits, even the solar energy. So there, but the Conference of Parties could have brought something new in a domestic perspective. But some way it has got the news has come. It may happen, may not happen, we don't know. But that has covered that government has almost decided not to have Conference of Parties meeting on 2028. So it's a big event, but some way. So under the conference, so the current situation is there. If I take you to the Paris Agreement, and that is the benchmark that entire global community is working towards ensuring that that the global temperature should pre-industrial level, that is remain pre-industrial level, that is 1.5. And that is the main objective of the international community, working very hard, ensuring that some way it remains. And we all are working on that particular directions. Use of non-fossil resources, how much we can reduce. These are the challenges we have in particularly. When we talk about the environment or sustainability, the conflict begins from this particular point. And as we all have been witnessing, the slogan in the in time of the election, it has moved from the other generic or common issues. It has moved to the new issue or new aspect almost for a decade, that is the development. Some way development has come in forefront in the global level or local level, particularly in the local level, development has become very important. So all human beings, citizens of the country, they desperately assess the function of the state for the creation of the infrastructure, continuous supply of electricity, generating employment, investment, and other things. If you take all these 4 or 5 aspects, it has some way going to disturb the ecological balance when we talk about the development. And that is the reason we have to think very carefully how the development and protection of environment go hand in hand, move properly, where large-scale destruction of environment should be avoided. At same time, development is essential, which needs to be there. So balancing is a very global, concern domestically or as well as the global level. I'm sure the conference which is going to take place, there are a lot of developments have taken place in the global, particularly UNFCCC, Conference of Parties, and even the Stockholm to Stockholm is completed 50 years. The 72 to 2022. So 50 years of Stockholm also. So there's a time, this is an occasion where I believe, particularly, sir, in the academic field, when we teach environment law, we focus more on our Environment Protection Act, Environment Impact Assessment, and series of cases of the Supreme Court and High Courts. We miss to teach also, if I say, and Honorable Vice Chancellor may correct me, that we also miss to teach the role of state pollution control bodies. We miss to also to teach central role of the central pollution control bodies. The power, there are a lot of powers are there. State pollution control bodies have a power to cut the electricity, close the, so there are a lot of powers are there. So some association with this subject brought to me that there are a lot of judgments also delivered by the lower court on the protection of the environment when it comes to the cutting of the electricity, supply of the water under the authorities, under the special state pollution control board. These are the challenges which needs to be taught to the students. And the cases decided by the subordinate courts also become an important tool where we can't think without environment. If environment, everybody talks about the MC Mehta, but it's SDM, that Bardhi Chand versus Ratlam municipality case, that has come to the Supreme Court of India, whereas subdivisional magistrate exercised his power, section 133 under the CRPC, and then in big jurisprudence. So much earlier, MC Mehta in 1980, that case we can consider very important. And I also would like, and we can work together with the National Law University and other associating party, that we can also in our syllabus give input to the international regimes also. So in isolation, it's not possible to understand this subject. We have to merge both the subjects, international and domestic law together to make our students informed citizens. They are the future. They are going to carry. We have played our inning, or remaining part will play, but not the 2020 will play now 50 overs match, so or test cricket. So our age has gone from the 2020, we are shifting to the test cricket, or maybe 14 overs we can play. So let the young generation be very informed regarding this subject, both theoretical and practical aspects. And I'm sure you are very fortunate. You have support of state government, which gives you the guidance. Officers working in the environment field can also play very important role in educating our students and also those who are involved in this subject. With this, once again, I would like to thank professionally to all of you, Honorable Vice Chancellor, sir, Honorable other members sitting on the dais, for giving me an opportunity to speak first. Thank you very much. So Yogesh sir, I will also leave because that's the reason I requested. So आप लोग मुझे permit कर दें तो, though I'm going to miss all of you, but allow me to take.
Thank you, sir, for that enriching and thought-provoking address. Your insights on international law and institutional frameworks add immense value to our conference theme. It is now my honor to introduce our next keynote speaker for the morning. Dr. Shumanta Chakraborty is a distinguished environmental professional and academic administrator with over 33 years of experience in environmental, renewable energy, pollution control, and higher education governance. He is a rare recipient of both the prestigious Chevening Scholarship UK 2002 and Fulbright Fellowship USA 2010, and also participated in the US State Department's International Visitors Leadership Program on urban environmental issues. During his Fulbright tenure, he worked with the United States Environmental Protection Agency. Dr. Chakraborty served in key roles in the government of Tripura, including environmental engineer at the Tripura State Pollution Control Board and project director of the Tripura Renewable Energy Development Agency. He led multiple World Bank, ADB, DST, MNRE and MOEF funded projects and played a pivotal role in implementing solid waste and hospital waste management systems across Tripura. He later held senior academic administrative positions as Deputy Registrar and Registrar in charge at NIT Agartala and NIT Manipur, and is currently the Registrar of MBB University. He has 11 research papers, presented 12 conference papers, guided MTech projects, and is co-supervising PhD scholars. Honored as Engineer of the Year 2019 by the Institution of Engineers India, Dr. Chakraborty is an active Rotarian, sports enthusiast, and social contributor with extensive international exposure across Europe, USA, and South Asia. I now invite Dr. Sumanto Chakraborty to deliver his keynote address.
Good morning, respected Vice Chancellor, sir. Just now we heard respected Vice Chancellor Professor Manoj Kumar Sinha. He already set the tune of today's theme. So, sir, Honorable Chair, distinguished guests, policymakers, scholars, and dear participants. What I will tell from my experience, and I will be specifically zeroed down to Northeast. As I born in the Northeast, I worked in the Northeast, and I studied mostly in the Northeast region. It is both a pleasure and a responsibility to address this august gathering on a theme that lies at the intersection of law, governance, ecology, and human survival, integrating legal framework and management strategies, pathways to a greener, sustainable Northeast. Just now, Professor Sinha talked about the Stockholm Conference, where our Prime Minister, Mrs. Indira Gandhi, participated. And there she told, poverty is the greatest polluter, which still persists in our country and particularly in the Southeast Asia. The Northeast region of India, comprising Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, and Tripura, holds immense economic potential due to its rich natural resources, strategic location, and proximity to South Asia and the Association of Southeast Asian Nations market. It also represents a convergence of unique geography, abundant natural resources, and rich cultural heritage. The northeastern region of India is not merely a geographical expression, it is an ecological treasure, a cultural mosaic, and a strategic frontier. It represents one of the richest biodiversity zones on Earth, forming part of the Indo-Burma and Eastern Himalayan biodiversity hotspots. This region is often described as India's ecological gateway to Southeast Asia. Yet, this ecological wealth faces mounting pressure from deforestation, climate change, urbanization, shifting cultivation, infrastructure expansion, and governance challenges. The question before us is not whether we can protect the Northeast, but how effectively we can align our legal system with sustainable management practices to secure its future. Northeast India is home to 2/3 of world's 36 biodiversity hotspots, thousands of endemic species, many still undiscovered, 67% forest cover, and over 443,000 families practicing ancient Jhum cultivation stands at a critical crossroads. Northeast India's 8 states occupy just 7.98% of India's geographical area, but account for approximately 21% of the country's total forest and tree cover. The India State of Forest Report 2023 records total forest and tree cover at 1,74,394.70 square kilometer, representing 67% of the region's geographical area. 6 of 8 states maintain forest cover over 75%, with Mizoram leading to 85.34% and Arunachal Pradesh holding the nation's second largest absolute forest cover at 65,882 square kilometer. The region sits at the confluence of Indo-Malayan, Indo-Chinese and Indian biogeographic limbs, creating extraordinary biological richness. The Eastern Himalayan biodiversity hotspot harbors approximately 10,000 plant species, out of that 3,160 endemic, 300 mammal species and 980 bird species. The Indo-Burma hotspots contribute another 13,500 vascular plant species, with 52% found nowhere else in the earth. More than 60% of India's bird species have been recorded in the northeast. The region shelters wild relatives of rice, banana, citrus, ginger and sugarcane, genetic resources of incalculable agricultural value. Kaziranga National Park alone protects over 2,200 one-horned rhinoceros, two-thirds of global pollution, and while Kelbil Jumbo in Manipur, the world's only floating national park, provides the whole sole habitat for the critically endangered Sangai deer. Arunachal Pradesh holds India's highest carbon stock at 1,021 million tons, making it the single most important state for India's carbon sink commitments. The nation's total forest carbon stock stands at 7,285 million tons, which is equivalent to 30.43 billion tons of carbon dioxide. And Northeast India's dense forests are central to achieving the enhanced target of 3.5 to 4 billion tons of additional carbon dioxide equivalent sequestration by 2035. Still, Northeast region is poor in economic indexes compared to mainland India. Yet, this wealth is eroding at an alarming rate. The region lost about 327.30 square kilometer of forest cover between 2021 and 2023 alone. Nagaland suffered the steepest decline, losing 794 square kilometer, roughly half of the area of Delhi, over the past decade. Only Mizoram and Sikkim registered net gains. The environmental threats facing Northeast India are interconnected and intensifying, and environment challenges span flooding to vanishing glaciers. The region's extraordinary ecological wealth faces accelerating threat. 387 square kilometer of forest lost in a single decade. A February 2026 mining disaster that killed 30 workers in Meghalaya, still thriving illegal mines. And the 2023 Sikkim glacial outburst flood that destroyed 1,200 megawatt dam and displaced 88,400 people. Flooding and erosion dominate in the Brahmaputra basin. Assam's flood-prone area encompasses 31.05 lakh hectares, which is 39.58% of the state, making it India's most flood-affected state. Annual devastating is staggering. The 2022 floods affected 9.3 million people and killed 181, the highest death toll in a decade, while the 2024 floods killed 109 people and displaced 400,000 people. Since 1950, river bank erosion has consumed in Assam 4.27 lakh hectares, which is 7.4% of its total geographical area, at an approximately 8,000 hectares per year. The Brahmaputra has widened to 15 kilometers at some point. Of 423 embankments built for flood control, 295 have outlived their intended lifespan, causing regular catastrophic breaches. Climate change is accelerating glacial melt with devastating consequences. Sikim's 405 glaciers and 640 glacial lakes are retreating rapidly. Glaciers are surfacing. Lowering rates increased from 0.19 meter per year during 1970 to 1983 to 0.87 meter per year during 2015 and 2023, a 4.5-fold acceleration. By 2100, approximately 80% of the Himalayan glacier could vanish at current warming rates. Mining has caused severe ecological damage, particularly in Meghalaya. Despite of National Green Tribunal 2014 ban on rat hole coal mining, approximately 24,000 illegal mines were found operational. Rivers like Kopili, Maithendu, Lukha have become too acidic to sustain aquatic life due to acid mine drainage. In February 26, a dynamite explosion at an illegal mine at East Jayantia Hill killed 30 miners, which is 12 years after the ban. Over 6,900 metric tons of illegal coal were seized in subsequent enforcement drives. Jhum cultivation accounts for approximately 0.76 million hectares in northeast India, 80% of the national total, with roughly 443,336 families dependent on shifting cultivation. The critical ecological concern is in the shortening fallow periods from the traditional 10 to 20 year span to just 2 to 4 year span due to population pressure, causing soil degradation, declining productivity, accelerated forest loss. Over 60% of Nagaland population practices Jhum, with approximately 20,000 hectares of forest cleared and burned annually. And wetland degradation threatens critical ecosystem. Deepar Bill, Assam's Ramsar site, has shrunk from 7.1 square kilometer to 5.2 square kilometer due to Guwahati's municipal waste dumping and encroachment. Loktak Lake in Manipur, the largest freshwater lake in northeast India, at 246.72 square kilometer, has been the Montreux record of threatened wetlands since 1993. Its hydrology fundamentally altered by the Ithai barrage built in 1983. Similarly, Rudrasagar Lake, a Ramsar site of Tripura, is rapidly shrinking. Friends, climate change is no longer a future threat. It's a present crisis, and in northeast region, we are experiencing it. Pollution is now an emerging concern in northeast. Traditionally seen as pristine, the region is now facing rising PM 2.5 levels, industrial and vehicular pollution, biomass burning, and so on. Community discussion and emerging studies highlight that many districts in Assam and Tripura exceeded national air quality standards. As a result, the northeast is now becoming a new pollution frontier. Even Agartala, the capital of Tripura, where this international seminar is being organized, ranking as one of the major air polluting city in India. Distinguished experts and participants, in this backdrop, let us dive deep into the existing legal system in India in general and northeastern region in particular. The legal architecture for environmental protection in India is robust. However, its effectiveness depends on implementation and integration and contextual adaptation. The Constitution of India provides strong foundation. As all of you are legal luminaries, Article 48A said, the state shall endeavor to protect and improve the environment. Article 51A said, our fundamental duties, it shall be the duty of every citizen of India. Further, 51AG said, to protect and improve the natural environment, including forest, lakes, river, and wildlife, and to have compassion for living creatures. The Supreme Court of India observed, environment protection is not a luxury, but a necessity. India possesses a comprehensive environmental legal framework, but its effectiveness in northeast India is severely compromised by implementation gaps, recent amendments, lack of political will, and fundamental misalignment with the region's unique and tenure and governance system. The Environmental Protection Act, as Professor Sinha has rightly pointed out, 1986, served as umbrella legislation, but enforcement remains weak. The 2020 Baghajan oil blowout in Assam near Dibru-Sikhowa National Park exemplified the EPA enforcement failure and failure on the part of State Pollution Control Board of Assam and Central Pollution Control Board. A landmark development came in March 2024 when the Supreme Court in M.K. Ratnajit Singh versus Union of India recognized a fundamental right to be free from adverse effects of climate change. And Article 14 and 21, a principle with profound implications of climate vulnerable Northeast India. The Forest Conservation Act 2023 represents the most consequential recent legal change for Northeast India. It narrowed the definition of forest to only those notified under the Indian Forest Act 1927 or recorded in the government records, potentially excluding the vast unclassed forest in Northeast India, that consisting 97.3% of Nagaland's, 88.2% in Meghalaya, 76% in Manipur recorded forest areas. Most critically, its 100-kilometer broader exemption allowing forest land diversion for strategic projects without clearance covers virtually all of Northeast, as 98% of the region's border are international. The Supreme Court's interim order in Ashok Kumar Sharma versus Union of India in February 2024 upheld the broader Godabardhanam definition, noting approximately 1.99 lakh square kilometer would otherwise be excluded. But the fundamental tension remains unresolved. Mizoram and Tripura assemblies passed resolution opposing the amendment. Nagaland demanded similar action. The Biological Diversity Amendment Act 2023 decriminalized violation, replacing imprisonment with fines up to rupees 50 lakhs, and exempted Ayush practitioners from benefit sharing requirements. For Northeast India, where indigenous communities hold extensive tradition and knowledge of medicinal plants, this exemption raises serious concern about exploitation without community compensation. The decriminalization reduces deterrence against our biopiracy in one of the world's most biodiverse regions. The Forest Right Act 2006 has been implemented in only 2 of 8 northeastern states, Assam and Tripura. Nagaland has not ratified it as per Article 371A requires state assembly resolution. Mizoram extended in 2009, then reversed the decision in 2019. Meghalaya, Arunachal Pradesh, Manipur and Sikkim have failed to implement it effectively. The Act's requirement to prove 3 generations of occupation on the same land fundamentally conflicts with Jhum cultivation, where families rotate field across large areas, and after implementation of Forest Right Act 2006 in Tripura, the forest cover is disappearing in a large scale, and human settlements, habitations, including Pakka buildings, are coming up in the forest areas. Under Compensatory Afforestation Fund Act 2016, nationally only approximately 27% of 51,300 crore allocated to states was utilized. Northeast states face a particular paradox. Funding non-forest land for compensatory afforestation is extremely difficult in states with 75% plus forest cover. Funds are often used for monoculture plantations rather than ecologically appropriate indigenous species restoration. Friends, the 6th schedule applicable to parts of Assam, entire Meghalaya, 3 autonomous district councils are there, Mizoram, 3 ADCs, and Tripura, 1 ADC, grants ADCs legislative power over forest, land, water, and Jhum regulation. However, enforcement capacity is limited, and as Meghalaya's coal mining crisis demonstrates, ADC governance structure can be co-opted by extractive interest. The National Green Tribunal has played a very vital role in environmental jurisprudence, ensuring speedy disposal of environmental cases, enforcement of the polluters play principle, application of the precautionary principle. There are huge gaps of implementation of law in the Northeast. Despite robust laws, challenges persist. Fragmented governance is largely because of overlapping jurisdictions between central, state, and traditional institutions. Autonomous district council control land and forest, which leads to overlapping jurisdiction, and all of us know the entire region suffers from implementation deficits despite strong laws. It was rightly said, effectiveness depends on enforcement. Due to weak enforcement of law in northeastern region, illegal mining, logging, and encroachments continues. Ladies and gentlemen, it is well understood that development activity is mainly responsible for environmental degradation in Northeast. For infrastructure expansion, like construction of road, highways, railways, there are reckless deforestation, habitat fragmentation, destruction of wildlife corridors are taking place. Few days back, we observed that in Teliamura region, one elephant was encroaching in urban areas and one lady died. Hydropower projects alter river ecosystem, displace indigenous population, and increase seismic risk. Another big environmental problem is mining and resource extraction. Coal mining in Meghalaya, oil extraction in Assam, quarrying across hill states, all these activities often proceed with weak environmental impact assessment, poor compliance monitoring. Absence of effective legal remedies aggravate the problems manifold. It is fact that geographical remoteness of Northeast restricts legal access, and low awareness among communities resulted to limited access to justice. Environmental cases take years, and due to delayed judicial process, the damage often becomes irreversible. Violators face minimal consequence due to weak deterrence mechanism. As I worked in the Pollution Control Board, as Professor Sinha was highlighted about the strengthening of pollution control boards, including the Central Pollution Control Board, but the irony is that in our country, the violators are smarter than regulators. It must be other way around. Regulator must be smarter than violators. Northeastern region is extraordinarily rich in natural resources, biodiversity, yet it remains economically underdeveloped and infrastructurally lagging compared to many other parts of India. It often described a land of plenty trapped in poverty. A region rich in resources, culture, and strategic importance, yet struggling with underdevelopment, isolation, and inequality. This paradox captures a profound contradiction. Friends, let us begin with the most striking contradiction and paradox. First, the economic paradox. Northeast region has rich resources but poor outcome. The Northeast covers nearly 8% of India's geographical area, contributes 3% industrial output, yet contributes only about 2.3% to the national GDP. This is despite vast oil and gas reserve in Northeast, hydropower potential in Arunachal Pradesh, rich biodiversity and forest wealth across the Northeast region. In states like Arunachal Pradesh, rural poverty affects nearly 40% of the population, while Assam records about 32% of the rural poverty, significantly above the national average. This reminds us the world's one of the best economists, Nobel laureate Amartya Sen, what he said: development is not merely growth of income, but the expansion of human capabilities. Clearly in Northeast India, growth has not translated into equitable development. Second paradox, let us discuss about growth. Rising economy but failing share. Takes the case of Assam. Growing up at nearly 7.9%, it was 2024-25 statistics, higher than the national average. Yet its share in India's GDP has declined from 2.6% to about 1.9% over time. This reflects what scholars call growth without proportional prosperity. Thirdly, the connectivity paradox, gateway, yet isolated. Geographically, Northeast India is India's bridge to Southeast Asia, bordering Bangladesh, Myanmar, China. Yet, it remains connected to mainland India through the narrow Siliguri corridor, which is popularly known as chicken's neck. And often we have observed that many people are telling about destabilizing Northeast and occupying this chicken neck. Fourthly, the infrastructure paradox, development versus accessibility. Infrastructure remains a key constant. Our irrigation coverage is around 20 to 25% versus 50% of national coverage. Agriculture productivity 20 to 30% lower than national levels. This is due to difficult terrain, floods affecting nearly 40% of arable land annually. Thus, despite government scheme, investment, last mile connectivity remains a major challenge. Fifth paradox, the peace paradox. Stability with underlying tensions. There has been a 73% decline in insurgency incidents in recent years, yet there still exists ethnic tension, border disputes, identity politics continue to affect long-term stability and investor confidence. Sixth, the environmental paradox, wealth versus vulnerability. Northeast India is part of a global biodiversity hotspot, home to nearly 50% of India's flowering plant species, yet climate change, floods, unregulated mining and deforestation pose serious threats. As environmentalist Sundarlal Bahuguna said, ecology is permanent economy. The region's future depends in respecting these principles. Seventh paradox, the cultural paradox, as again Professor Sinha was highlighting about the ethnic identity and diversity of Northeast. Cultural paradox is diversity versus marginalization. The Northeast is home to over 200 ethnic groups, hundreds of languages and traditions, yet many communities feel politically marginalized, socially disconnected from mainstream narratives. And finally, the eighth, the policy paradox, intent versus implementation. Government initiatives such as Act East policy, Northeast Special Infrastructure Development Scheme have shown promise, but huge implementation gaps, administrative inefficiencies, lack of local participation continue to limit their impact. To overcome these contradictions and paradox of Northeast, concentrated effort in terms of policy implementation, strategy, real-time execution, and effective legal system are extremely essential. The irony is the Northeast region that contributes least to environmental degradation suffer the most from its consequences. Ladies and gentlemen, the paradox of Northeast is not a story of failure. It's a story of unrealized potential. To transform this paradox into progress and possibility, we must focus on inclusive and participatory development, sustainable resource utilization, robust infrastructure and connectivity, stronger governance and policy execution. My dear friends, in such a complex scenario, we must devise a comprehensive strategy for all-round development of Northeast region. The states across the Northeast have made several strategic interventions which have been incorporated concurrently in their policies. Ironically, the prime of these policies were for industrialization. And one such recent policy is the Uttar Purba Transformative Industrialization Scheme, Unnati 2024. Northeast region is poised to emerge as a sustainable growth frontier, a green industrial hub, an innovation-driven startup corridor, and a strategic pillar for the India's Act East policy. The region is uniquely placed to redefine the investment promotion in India by embedding ecological balance, cultural heritage, and community participation into its sustainable framework. But the reality is that apart from industrialization, we are not emphasizing other sectors in Northeast, which is needed for sustainable development and ecological balance. The Northeast region offers significant untapped opportunities. It is home to high-value niche sectors such as organic agriculture, wellness tourism, electric mobility, IT-enabled services, and natural products like agarwood, medicinal and aromatic plants, and mineral resources that have significant potential for growth and investment. Tourism is to be broadened under a unified national, regional strategy with joint circuits and community equipped model. In Northeast, sustainability is not a modern invention. It's an indigenous practice. The Northeast has a long tradition of community stewardship, sacred groves, community forest, indigenous conservation, ethics, and our strategy should be more focused on these areas. I am giving one or two examples here. Meghalaya community-based management forest represents a uniquely effective model. At least 11 types of community forests there exist. In Nagaland, 407 documented community conserved areas managed under customary law protected by Article 371 cover 1,700 plus square kilometer and store approximately 120.77 tons per hectares of carbon. In Tripura, all of you know about the agarwood policy, which can fetch around rupees 20 billion economy within next 5 years. All these systems align with modern sustainability principle is echoing the famous saying, the earth does not belong to us, we belong to the earth. Dear participants, we can again take example from our many success stories of Northeast. The Aptani wet rice cum fish culture cultivation in Zero Valley, Arunachal Pradesh represents millennia of accumulated ecological engineering. The Zebo system in Chakansang tribe in Nagaland similarly integrate forest with water, crops, livestock and aquaculture, and the practice is going on for years together. Sacred groves represent another critical integration point. The UNDP's Northeast India biocultural initiatives demonstrate how international framework can support community-led conservation. With several northeastern states maintaining 75% forest cover and storing vast carbon stocks, community managed forests could generate substantial revenue through verified carbon credits. Nagaland CCA alone store an estimated 120.77 tons of carbon per hectare. Payment for ecosystem services model valuing watershed protection, carbon sequestration and biodiversity conservation are particularly suited to Northeast India's landscape, where upstream communities maintain forests that benefit downstream population across international border. Friends, these technical capabilities are not systematically linked to legal enforcement or community governance. Real-time satellite monitoring of forest loss could trigger automatic legal compliance, GIS-based mining area, mapping could be support the NGT, National Green Tribunal enforcement, drone surveillance could protect wildlife corridors, a unified Northeast environmental monitoring dashboard connecting NESEC data, state pollution control boards, National Green Tribunal and community institution would transform enforcement capacities. For last few years, many steps were taken and strategies were formulated for holistic and sustainable development in Northeastern region. In this context, Niti Aayog's working group on shifting cultivation reached a crucial finding. No single technology can replace Zoom universally. Solution must be context specific based on topography, food preferences and land tenure. My dear friends, India's national determined contribution, our NDC commitments and national frameworks elevate Northeast India's strategic importance. India's updated NDC target 45% reduction in emission intensity by 2030, net zero by 2070, and the enhanced 2035 target of 47% intensity reduction with 3.5 to 4 billion tons of carbon dioxide equivalent additional carbon sink make Northeast India's forest a national strategic asset. The region has already achieved 52.57% non-fossil electric power capacity nationally surpassing the 50% target. But the Northeast India's 62,000 megawatt solar and 56,480 megawatt hydropower potential, representing 40% of India's untapped hydroelectricity, remained largely underdeveloped. A February 2026 conclave in Guwahati highlighted 130 gigawatt of untapped green power potential in Northeast. The Niti Aayog SDG India Index 2023-24 shows Northeast state improving. Sikkim leads at 76, Manipur and Mizoram at 72, and all Northeast states except Meghalaya and Nagaland now in the front runner category. The Northeast region district SDG Index, Sustainable Development Index 2023-24 reveals that 85% of the Northeastern districts are now in the front runner category, up from 62% in 2021-22, with Mizoram leading at 81.43. These improvements demonstrate institutional capacity for progress when resources and frameworks align. At the same time, we must promote eco-friendly industry and developmental projects in Northeast. The negative list within the Northeast Industrial Development Scheme 2017 is a commendable step, ensuring that entities adhering to environmental standards receive incentives. If an entity is not complying with environmental standards, not having applicable environmental clearance, does not have consent from the concerned pollution control boards, it will not be eligible for any incentive under the scheme and will put on the negative list. The Act First for Northeast policy should not only include trade and commerce, but also the preservation of environment and ecology in the region. My dear friends, to develop Northeast in a vibrant way, we must take lesson from international best practices of Costa Rica, New Zealand, Norway, and other countries. For example, in Costa Rica, the payment for ecosystem service was successfully introduced. And we should take note from the concept of legal rights to rivers implemented in New Zealand. On the other hand, Norway has strong enforcement and transparency in administrative system. All these international models emphasize accountability, community participation, strong institution. The Northeast stands at a critical juncture, but the question is not whether to develop, but how to develop sustainably. Despite strong legal frameworks, the real challenge lies in the effective implementation, institutional coordination, and alignment with ground realities. The way forward demands integration of law with local knowledge, policy with participation, and development with ecological balance. Community-led conservation supported by strong governance and technology must form the core of this approach. The Northeast must not be treated merely as a resource frontier. It must be recognized as a biodiversity sanctuary, a cultural heritage zone, a climate buffer for India. The Northeast is not just a regional concern. It is a national and global ecological asset. Protecting it requires strong legal frameworks, effective management strategies, community participation, and of course, scientific innovation. The path forward lies in integration and assimilation, not in isolation. Let us move from policy to practice, from laws to livelihoods, from exploitation to sustainability. And we successfully integrate law with local knowledge, development with ecology, policy with participation, then the Northeast can become a global model for sustainable development. And if we act decisively, the Northeast can transform its challenges into opportunities and emerge as global model for sustainable development. And if not, we risk losing an irreplaceable ecological and cultural heritage. Ladies and gentlemen, I am not pessimistic. The choice is ours, and the time is act just now. Otherwise, as our ancestors 3,000 years back described in Nasudya Sukta of Rigveda that सृष्टि से पहले ना सात था, ना असत था, ना अंतरिक्ष था, na akasi the, unquote. Our future will be like that, and we may go back to that stage. Thank you very much. Hambai, Jai Hind.
Thank you, sir, for the deeply insightful address. Your experience truly highlights how governance and environmental responsibility must go hand in hand. We now move to our final keynote speaker for this session. Dr. Egosa Ekato is Associate Professor of International Environmental Law at the University of Derby, United Kingdom. His main research areas include international environmental law, African international legal history, and natural resources governance. Dr. Ekato has published extensively on his research areas, and his academic papers have been cited by a plethora of public and international agencies, including the United Kingdom, Parliament's International Trade Committee, and the United Nations Refugee Council. Dr. Ekato is also the Chair Committee on the Teaching of International Law and the SDGs, International Law Association Nigerian Branch, and Senior Fellow Environmental Law and Sustainable Development, Institute for Oil, Gas, Energy, Environment and Sustainable Development, OGEES Institute, F. Babalola University, Nigeria. Dr. Ekato is the Deputy Editor-in-Chief, the Journal of Sustainable Development Law and Policy, F. Babalola University, Nigeria. Dr. Ekato is also a visiting professor of law at the Benson Idahosa University, Nigeria. Sir, we are truly delighted to have your global perspective enriching this platform. I now invite Dr. Egosa Ekato to kindly deliver his keynote address.
Good morning, everybody. Good morning from the UK. I don't know if you can hear me, and thank you for the opportunity to be part of this amazing program. I'll just see if I can share my slides briefly so I can discuss about. Can you see my slides, please?
It's visible, sir, and you're audible as well.
Okay. Good morning, everybody. This is Egosa Ekato. I'm an associate professor of international environmental law, and my research area involves environmental justice, both from a global north and global south perspective. I've done a bit of research on Nigeria and India, so I'm just going to give my perspective on how India and Nigeria can collaborate. Nigerian scholars and Indian scholars can come together and try and collaborate in the fight to promote environmental justice in both countries. So I'll just quickly run through what I have for today. I know I've got about 10 minutes. I'll just provide some definition of environmental justice, discuss right to environment from both the Indian and Nigerian perspective, how does it impacted on environmental justice, and how I'll make some recommendations and the conclusion. So in a nutshell, what I'm trying to say is that because of the experience of Indian environmental justice sort of jurisprudence or environmental rights jurisprudence, it has had some positive impacts on Nigeria environmental litigation as well. So the first thing to talk about is how do we define environmental justice? We've been using the term environmental justice throughout this conference. So there are different definitions of environmental justice. Environmental justice started from issues around ethnic minorities in the USA, where many of them were victims of oil pollution, were victims of chemicals being brought to their vicinity, etc. So environmental justice started from the USA, from the activities of civil rights activists in America, but environmental justice is no longer limited to the US sort of context, and it has spread throughout the world. It's now applied to various serious social concerns, particularly those related to communities that suffer from social inequity attributed to environmental inequality. So and also environmental justice can also be contextualized. It can also, so even though it's a broad theory, it's a broad framework, it also has some contextual sort of implications. So it has become a global movement and is no longer limited to the experiences of ethnic minorities in the USA. Also, Professor Agema argues that there has been an acceptance among senior figures in U.S. environmental justice movement that while race is a major factor in U.S. struggles, in other parts of the world, a broader set of economic issues are at least as influential. From a Nigerian perspective or an extractive country perspective in Africa, access to resources, control of resources are some of the criteria that is used to define environmental justice. Whereas from an Indian perspective, class could be one of the ways to look at environmental justice. From a South African perspective, the impact of apartheid also affects how environmental justice is analyzed from a South African perspective. So yes, environmental justice is broad. It applies to various sort of issues, but at the same time, it has some contextual underpinnings depending on the sector, depending on the country as well. So, and also in terms of global south, how do we define the global south? There are different definitions of the global south. India and Nigeria are both in the global south. So, in my view about the global south is that it's just one way to look at how countries are analyzed through a certain prism. Even though Professor Souza Santos believes that the global south is not a geographical description, but rather a metaphor for the human suffering caused by capitalism and colonialism on the global level, and speaks of a South that also exists in geographical North in the form of excluded, silence, and marginalized population. My idea of the global South is just mainly it represents a third world countries, represent countries who are similar sort of economic development, and Nigeria and many African countries can also be categorized as countries in the global South to a certain extent. So as I was saying earlier, in terms of defining environmental justice, environmental justice in Africa emphasizes access to natural resources, while in the USA and the UK, they focus on maintaining the planet's well-being via active public participation. So from an African and Nigerian context, there's a distinct connotation of environmental justice. As I said earlier, access or control of natural resources by the people of Niger Delta, where the oil and gas industry is predominantly located, are some of the factors that underpin the definition of environmental justice in Nigeria. So this idea of environmental justice, as I said, is no longer limited to the US. It has spread to different parts of the world: Nigeria, South Africa, Brazil, India, etc. So one of the ways that countries, law plays a very, very important role in the promotion of environmental justice. We can rely on law and legal framework to actually enhance access to environmental justice. So in this presentation, I just briefly look at the role of the right to environment as a tool to promote environmental justice. And this is very, very important from a Nigerian and Indian perspective, where ordinarily right to environment are not constitutional provisions, but the courts have read justiciability to the right to environmental provisions in both Nigeria and India. And the Indian courts have had a very positive influence on how Nigerian courts are conceptualizing some of their cases on environmental litigation. So in terms of right to environment as a tool to promote environmental justice, in many countries in the world, the right to environment provisions in the constitutions and laws have served as a strategy that have been utilized by different stakeholders, including NGOs, communities, victims, litigants, and environmental injustice victims as one of the strategies to hold government and other actors such as multinational corporations, government agencies accountable for environmental injustices in many countries in the global south. So recourse or reliance on rights to environmental rights can also be used to conceptualize environmental justice issues. So in some of my research, I've also argued that environmental justice is similar or akin to environmental rights. The concept of environmental rights has attained some level of international recognition, and there's an international recognition of the concept of environmental rights. So also the right to environment is recognized in constitutions of several countries. A lot of people have said that currently more than 160, 170 countries or national constitutions do have some form of recognition of environmental rights in its provision. So from an India perspective, India is one of the most progressive countries in terms of judicial awareness and application of contemporary concepts, including environmental rights and notions of sustainable development. This has meant that the protection of environmental rights and recognition of sustainable development is quite encouraging from a legal perspective. I know there are issues around lack of political will, issues around pollution, but if you look at it from a legal perspective and what the courts are doing in India, India is like an exemplar in how to use the legal framework in terms of the judiciary as one of its tools to promote environmental justice. So similarly, India's constitutional provision on environmental human rights, it's quite similar to what obtains in Nigeria. Article 48A of the Indian Constitution talks about environmental provision. Article 51A on fundamental rights. This is quite similar to what we have in Nigeria, where environmental protection is said to be in the general provision of the Nigerian Constitution, a non-enforceable constitution, which the courts has also said can be made enforceable by relying on that sort of justiciable part of the constitution as well. So from an Indian perspective, scholars like Rajan have argued that the idea of environmental justice is known, is popular, is well accepted, even though it's a relatively recent concept. On the other hand, Kashran argues that although India is home to millions of environmental injustices as well as hundreds of long-standing grassroots environmental justice movements, yes, environmental justice is not mainstream, is not on the mainstream policy radar in India. According to Kashran, says there are no EEG policy or program at the central level or at the states. Hence, the role of the Indian judiciary as a strategy to promote environmental justice become very, very important from an Indian perspective. Because I was listening to the other speaker in terms of when he was talking about lack of political will, the negative impact of environmental injustice in northeast part of India. So this also brings to the fore why we need the judiciary, why we need judicial activists, why we need scholars, academics, and legal practitioners to ensure or use the legal framework as the tool to promote environmental justice in India. So I will just run through this. I know everybody's conversant with this part about how India Constitution contains specific provisions for environmental protection, which falls under the chapters of directive principle of state policy and fundamental duties. However, Indian courts in several cases have recreatively booted life to these approved provisions by linking and enforcing these issues to constitutional guarantee right to life in Article 21. So also the role of the National Green Tribunal is also a very, very important part in this how to promote environmental justice in India. I know that the Green Tribunal has got some issues in terms of number, and it has not really lived up to its expectations. But India is one of the few countries in the world that actually has a standalone environmental tribunal or a CASA legal court that actually does stuff around environmental justice issue, which is a very good positive, and many countries are trying to adapt this idea from this environmental justice tribunal from an Indian perspective. So Professor Gita states that India's senior judiciary advocates environmental constitutionalism through environmental care paradigm. Indian cases have many courts in the global south, even in different parts of the world, Australia, etc. There has been some influence of the Indian jurisprudence on environmental sort of discourse in different parts of the world. Scholars, academics, legal practitioners, judges do refer to the jurisprudence arising from Indian courts. So from a Nigerian perspective, this heading is correct. It's climate litigation in India, not in Nigeria. So there have been recent developments regarding environmental justice and climate change impacts in India. In 2024, the Indian Supreme Court, in the Rajan Singh others case, stated that there is a constitutional right to be free from adverse effects of climate change by drawing upon Article 21 and Article 14 of the Indian Constitution in this regard. So some scholars have said that this recent Indian Supreme Court judgment shows how Indian courts are trying to trying to use existing legal frameworks to tackle current issues. When Indian Constitution was developed, climate litigation did not exist. Awareness about climate change issues was not the way it is now. But the Indian judiciary has been able to use these constitutional frameworks to tackle contemporary environmental justice issues. So Indian courts are known for interpreting constitutional provisions considering modern day environmental issues in the country. So from a Nigerian perspective, Nigeria is a site for environmental injustice, especially in Niger Delta region. The Nigerian Constitution, similar to what happens, occurs in India, does not have explicit right to environment provision. So Article 20 of the Nigerian Constitution stipulates the government should protect and improve the environment and safeguards water, forest, etc. As I've said before, this section 22 of Nigerian Constitution is not justiciable. Socio-economic rights ordinarily are not justiciable in Nigeria. They are found in Chapter 2 of the Nigerian Constitution. Civil and political rights are justiciable in Nigeria. Those are found in Chapter 4 of the Nigerian Constitution. So because of this lack of environmental protection and access to justice, many NGOs and victims have relied on the African Charter on Human Purpose Right. The African Charter on Human Purpose Right has been domesticated as a law in Nigeria. It's a regional treaty, domesticated to Nigerian law, and the African Charter explicitly promotes right to environment in its provisions. And in a recent decision in Nigeria 2018, the Nigerian Supreme Court, the Center for Air Pollution Watch, and NNPC, Nigerian court liberalized local standard for NGOs and said that NGOs do have the ability to institute cases on behalf of environmental victims in Nigeria. And Nigerian court expressly relied on the provision of Article 24 of the African Charter of Human Rights, Section 33(1) of the Nigerian Constitution, and Section 14, subsection 4, 17 subsection 4 of Oil and Pipelines Act Nigeria told that right to environment can be justiciable in Nigerian sort of perspective. So influence of Indian jurisprudence in Nigeria. Nigerian courts regularly refer to Indian case law in judgment, especially involving environmental rights litigation and similar issues. So it is a well-known fact that Indian courts have been of persuasive value to many courts in the global south, in Nigerian courts. So this case I've just mentioned, the Center for Air Pollution case, the Nigerian Supreme Court explicitly relied on Indian case law in that judgment, explicitly relied on Indian scholars in that judgment as well, which shows how the influence and impact of what is happening in India can also be of massive positive influence in other parts of the world. And this is represented Center for Air Pollution case in Nigeria. So in terms of recommendations, to just briefly close this my keynotes, I've made 2 recommendations in terms of, 1, collaboration and instituting cases in different countries by NGOs. So I think there should be more sort of integrated synergy between Indian scholars, Indian academics, Indian judiciary, and Nigerian scholars and Nigerian judiciaries. For example, there can be training by the Indian judiciary for Nigerian judges. There can be cross-border academic collaboration, funding to develop ideas around environmental justice. So collaboration between Western and non-Western NGOs could also help in this regard. Collaboration between Indian and Nigerian NGOs could also help in this regard. Also, instituting cases in foreign jurisdictions like in the UK and in Netherlands, etc., could also help in promoting environmental justice for victims in Nigeria and India. So NGOs and communities also utilize litigation as a strategy to promote the environmental justice. So the use of litigation is also very, very important. And due to judicial and other institutional impediments in holding multinational corporations accountable for their actions in the global south countries, many NGOs do institute cases in foreign jurisdictions. So as I said, collaboration is also key in this regard. So both countries can actually collaborate to ensure that environmental injustices are reduced in both countries. So in conclusion, I leave everybody with the word of Professor Robert Bullard, who is said to be the father of environmental justice, who's one of the earliest scholars of environmental justice, one of the first people that started tackling environmental justice issues from a strict environmental justice lens from the US perspective. So while Professor Bullard was discussing the utility of environmental justice paradigm from a US perspective, in a paper he wrote in 2021, he states, 4 decades ago, the concept of environmental justice was a mere footnote. Today, environmental justice is a headline registering on the radar of the media, green groups, civil rights, human rights, and racial justice organizations, social media networks, academic consortia, educational institutions, at least one of the major political parties. So this is something which also reflected from our own perspective in the Indian and Nigerian sort of legal scholarship or judiciary or court decisions. Environmental justice is no longer a footnote in both countries. Environmental justice has gone mainstream. The language of environmental justice activism, there are a lot of NGOs, a lot of litigation, a lot of cases taking place in both countries, Nigeria and India, which shows that environmental justice, even though it came as an idea from America in its current form, has been able to permeate into the legal discourse and social discourse in both Nigeria and India. So in my view, environmental justice scholarship is no longer relegated to the academic and legal backwaters in both countries, and it has gone mainstream. Thank you very much.
Thank you, sir, for that insightful and globally grounded perspective. Your address has truly broadened our understanding of environmental governance across jurisdictions. With that, We come to the end of this enlightening keynote session. Today's discussions have reinforced the importance of integrating law, governance and management strategies to address environmental challenges, particularly in regions as dynamic and sensitive as the Northeast region. I now invite Professor Dr. Shoykot Chakraborty to kindly deliver the vote of thanks.
Good morning, one and all present here. It is my proud privilege to propose the vote of thanks for the International Conference on Integrating Legal Frameworks and Management Strategies, Pathways to a Greener, Sustainable Northeast India, IFLMS 2026. At the outset, I would like to express our deepest sense of gratitude to our esteemed distinguished members for their valuable guidance and encouragement. We are highly obliged to Professor Dr. Yogesh Pratap Singh, Honorable Vice Chancellor, NLU Tripura, for his constant support and inspiration. I also extend our sincere thanks to Professor Bonani Chakraborty, Honorable Chancellor, UEM, Kolkata, and Professor Dr. Satyajit Chakraborty, Honorable Vice Chancellor, UEM, Kolkata, for their visionary leadership and encouragement. We express our heartfelt gratitude to Professor Dr. Nochiketa Mittal, Registrar, NLU Tripura, for his wholehearted support and cooperation in making this conference a success. I express my sincere thanks to our distinguished keynote speakers, Dr. Shumanta Chakraborty, Registrar, Maharaja Bir Bikram University, Agartala, Tripura, India. Professor Dr. Manoj Kumar Sinha, Vice Chancellor, Dharmashastra National Law University, Jabalpur, India, and Dr. Egosa Ikato, Associate Professor, University of Derby, United Kingdom, for their insightful deliberations which have greatly enriched this conference. I would like to express my thanks in advance to all the session chairs, moderators, and rapporteurs for their dedicated efforts and for ensuring the smooth conduct of these sessions. We are equally thankful to all the presenters for their valuable research contributions and active participation, which added immense depth to the discussions. No event is in this magnitude can be successful without the enthusiastic involvement of students and research scholars. They are truly the lifeblood of any institution, and we extend our heartfelt thanks to them for their tireless support and commitment. Our sincere gratitude goes to all the organizing committee members, advisors, academic and non-academic staff, support staff, technical staff, photography team, as well as all stakeholders who have directly and indirectly contributed to the success of this conference. I would also like to place on record my heartfelt and deepest appreciation for my fellow conveners, Dr. Ripan Bhattacharya, Dr. Bandita Shetgupta, and Dr. Dibyendu Chattaraj. My colleagues of UEM, especially Dr. Sravana Chattopadhyay and Professor Victor Nayak, all the faculty members of NLUT for their unwavering support and collaboration. With this, I conclude my vote of thanks for this session of the conference of ILF-MS 2026. Thank you all.
Thank you, sir. Now we will go for a tea break. After that, the technical session will start. Technical session 1 will be held in offline mode here at the auditorium, and technical session 2 will be held in online mode. I would like to request the moderator and rapporteurs of an offline session to accompany the chair to the venue. Moderator and rapporteurs of online sessions are also requested to join online as per their schedule. Additionally, it is also informed that technical session 3 will be held in offline mode as well here in the auditorium, and technical session 4 will be held in online mode. Moderators and rapporteurs of technical session 3 are also requested to accompany the chair of particular session to the venue at the respective time, and moderators and rapporteurs of online session are requested to join online as per their schedule. Now we can break for a short tea break. After that we will